One of the key steps in any criminal trial in Canada is that you're required to have a Crown pretrial. Now, what is a Crown pretrial? Well, first of all, it's also known as a resolution meeting, a Crown resolution meeting. It simply means that you've already met with your client, you've received disclosure, and you've received instructions from your client after providing your client with a legal opinion. Your client might instruct you to negotiate the best possible resolution, or your client might say, look, we're heading to trial, or they might be on the fence, depending what the Crown comes back with. So we have this meeting with the Crown where we're essentially reviewing most aspects of the file. We're receiving the Crown's position, you're presenting the client's background, what type of person they are, and reviewing the strengths and weaknesses of the case. It's kind of a fulsome discussion about the case, especially if you're trying to negotiate a deal. And hopefully the Crown and you can come to a joint submission, which you're for sentencing, which means you both agree on a sentence, for example, no jail. Your client might be happy with that. Or the Crown might say, no, we're asking for 3 years in jail. Well, I think it's worth 1 year, Mr. Crown. And you're then either A, heading to trial, or B, appearing in front of a judge, and the judge will have to make a decision about how long the jail term will be, or if a jail term can be avoided. The other thing that happens at a Crown pretrial is, especially if you're heading to trial, obviously if you're heading to trial, is you have a fulsome discussion about the trial issues. We're trying to manage court time in the province, so we have to know, the witnesses that are being called by the Crown, the basic legal issues, how many witnesses are being called by defense. So we're managing court time, so we come up with an estimate of court time before we go to set the trial date. If there's a charter application, meaning there's a constitutional challenge to certain evidence, we have to disclose that to the Crown. That's a requirement. So we have a discussion about that. Maybe you can convince the Crown to withdraw the charge if you've got a great charter application. So these meetings can go on and on too. On complicated cases, there's sometimes many meetings with the Crown which evolve over months of time, especially as you get new disclosure in from the police that might strengthen or weaken the case. So the bottom line, it's a fulsome discussion with the Crown. Now, one of the things that a defense counsel should not do at a pretrial, if there's a defense that's not so obvious, for example, a DUI charge might have a technical defense that's hidden within the police notes, you don't necessarily disclose that to the Crown because you don't want the police to shore up the defense. So sometimes you kind of have to wait in the weeds and stay silent on defense and say, hey, it's a prove-it trial. It's going to be a 1-day trial, 2-day trial, 3-day trial. And the Crown, you hope the Crown doesn't even look at the file that carefully. And generally they don't at that stage on a minor case. They've looked at it for maybe an hour or two when you've examined it for 10 hours and found that technical defense. So that's what happens at a Crown pretrial. Again, they might go on and on for many meetings, or it might just be one and head to a guilty plea. After the Crown pretrial happens, the next step is to get further instructions from your client and either have another pretrial or set it what's called a judicial pretrial. And I'll talk about judicial pretrials in another one of my videos. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.